Well, good morning, everyone. This is John Neerman, and it's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, February 24th, 2021. The time is 9:31 a.m. I'm rarely late. I promise never to be early, but I'm occasionally late. So it's 9:31, and let's begin with a roll call. Commissioner Lindley, good morning.
Good morning.
And good morning, Commissioner Janeka.
Good morning, Chairman.
Our commissioners are all present. How about our general counsel? Ms. Smith, are you there?
I am. Good morning.
Good morning. And our public interest counsel?
Good morning. I'm here.
Good morning, Mr. McWhirter. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov and include your name, affiliation, and the item that you'd like to comment on, and we'll do our best to accommodate that request. For those who are making presentations, please wait to begin your presentation until I or our General Counsel have asked you to begin speaking. And please check to make sure that your line is unmuted before you speak. Colleagues, there's a few items that I'd like to address before we get into the notice items. First, I just have to acknowledge the difficult week that we've just been through and the misery and anxiety and harm that it caused across the state. The unprecedented weather disaster quickly became an unprecedented energy crisis, which set off cascading crises, including to supply chains, and as it relates to our jurisdiction, a crisis for public water systems. Last Thursday, more than 16 million Texans were under a boil water notice, and that, as you know, is more than half of the state's population. And on that same day, more than 365,000 Texans had no water at all. And I know you agree with me that we simply can't allow this to happen again. Executive Director Baker has already announced a review of this incident with the objective of first understanding in a comprehensive way precisely where the failures occurred, and then working with our stakeholders to implement policy changes to mitigate, if not prevent, these failures in the future. And the Commission has noticed and is scheduled to hold a public work session on this subject next Wednesday beginning at 2 p.m. We have made dramatic progress in the last week, but this is an ongoing crisis. As of this morning, the boil water notice has been lifted for more than 13 million Texans, but it remains in place for just over 3 million people. And just over 13,000 Texans remain without water this morning. I need to thank the water system operators, their repair crews, even friends and neighbors who are handy with soldering torches, who continue to work this crisis and have worked around the clock to restore water. And I have to thank agency staff who, as they themselves were shivering without electricity or melting snow to flush their toilets, nevertheless worked around the clock to continue to assist the public and the regulated community in coping with this disaster. And that really included all corners of the agency, including our own General Counsel's office, who were working under very difficult circumstances on battery power to get us ready for this meeting this morning. So that's the first topic, the water crisis. Next, just briefly, don't lose sight of the fact that we remain in the grips of a deadly pandemic. In dealing with this weather disaster in our own neighborhood, my personal social distancing was not what it could have been, and really there were more pressing issues than social distancing during those days. I just want to encourage everyone to continue to protect yourselves and protect each other. Wear a mask, continue practicing social distancing, or if you're like me, resume that, and please get the vaccine when it's available. Finally, I'd like to note that February is Black History Month, and I wanted to highlight that as part of the agency's programming for this, we've developed a series of videos that profile a few of our employees. And among other purposes, these videos are part of an outreach effort to young Black and Latino students to help them see the possibilities for their own lives in the environmental fields. And so to our employees, Jake, Naomi, Frederick, thank you for sharing your stories. I watched those videos with my daughter. We love them. My daughter, Naomi, has a tree house and is a tree hugger. We especially identified with that one, so thank you. I'm also very excited as really part of this set, the former TCEQ chairman, John Hall, has worked with us to put together a video where he talks about his own life and his experience at the commission and his reflections on Black history and the state of really racism in our nation today. It's a wonderful piece. I'll let it speak for itself. We're going to post that tomorrow, and I encourage you all to take a look at that. So, colleagues, thanks for indulging me and getting us a little running off on a tangent to our agenda, but I did want to highlight those 3 points this morning. Before we go on, is there anything that you all would like to add or say, Commissioner Lindley?
You know, as usual, your opening remarks are tough to compete with. That was very well said. You know, I think about how many times I've probably said and thought I couldn't be prouder of this agency and couldn't feel more privileged to represent them in the commissioner role. And this past week truly has skyrocketed those feelings for me. And, you know, the world will never know how hard our employees work. And if I could be queen for a day, I'd change that. But like you stated, you know, we had employees, myself included, you know, melting snow to flush toilets. We had employees sitting in their cars trying to power their cell phones so that they could be in touch with water treatment, drinking water plant operators, trying to get boil water notices rescinded. The lengths people went to for their fellow Texans was remarkable, and they're still doing it. So I'm just so proud. You know, I do look forward to work session next week. I think there's going to be good things that come out of this. And I just echo everything you said. As far as the other topics, the videos have been outstanding. I mean, when I saw them, I thought, did we produce these? They're very well done, just from a production side. But they're also very powerful, and really appreciate TCEQ staff and former Chairman Hall for agreeing to do those and open up and share a little of their lives with the world, because I do think it's going to benefit the agency and hopefully future generation of TCEQers. So I will stop there. Thank you.
Thank you, Commissioner Lindley. Commissioner Janeka?
I really don't think I can add anything else. Y'all both made very good points that I agree with 100%, and I'm just very glad that we will have the chance to sit down, circle back next week to look back at the events of this past week. The steps ahead of us and all other state government entities in the weeks and months ahead very much point to look backward, see what we could have improved on, what didn't work as we intended, and be better. And the second point you brought up, Mr. Chairman, I think is very much in that spirit very much as well. We're constantly working as a society, as an agency, as a state, as a community to reflect on our past and look for our future. So I look forward to doing that with all y'all. Thank you.
Thank you, colleagues. Appreciate that. And Commissioner Lindley, thank you for providing a little bit more texture to my comments and some of those anecdotes. Our staff really did an outstanding job. I don't know if our resident filmmaker was working on battery power, but he managed to produce an outstanding video during this disaster. So Aaron Gallup, I need to thank you as well. With that, thanks everybody for indulging us, and thank you for being present. Ms. Smith, I'm going to ask you to go ahead and call the docket, and I understand the first item is continued.
That's correct. It's been continued to the March 10th agenda. So our first item will be item number 2, the ALJ's proposal for decision and order regarding an enforcement action against Tony Aguilar and Benita Castillo Villasenor. The order of presentation should begin with the Executive Director, followed by the respondent and the Office of Public Interest Counsel. By letter dated February 5th, 2021, the Office of Chief Clerk provided each of the parties with 5 minutes of oral argument time in accordance with the Commission's standard practice. The ED may save time for rebuttal as the ED bears the burden of proof.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Audrey Leiter, and I am an attorney in the Environmental Law Division representing the Executive Director in this matter. With me today are Jake Marks of the Litigation Division, Robert Gilliam of the El Paso Regional Office, and Donna Chafin of the Financial Administration Division. This enforcement action involves one violation for unauthorized disposal of industrial solid waste at a property owned by respondents and in violation of a commission-issued agreed order. After a hearing on pretrial motions on June 30th, 2020, and the evidentiary hearing on September 8th and 9th, 2020, the ALJ found that the ED demonstrated that respondents violated a commission order and TCEQ rules. Further, the ALJ agreed with the ED that an administrative penalty in the amount of $184,500 was properly calculated in accordance with the TCEQ penalty policy and the Texas Water Code, and recommended the ED's proposed corrective action. The ED filed minor exceptions to the ALJ's proposed order, all of which were sustained by the ALJ. Respondents filed objections to the ALJ's proposal for decision and proposed order. The ED's position is that respondents' objections generally misstated the alleged violation in this enforcement action, including the nature of the violation and the alleged violation dates, and restated their arguments and objections made and ruled upon during the hearing on pretrial motions and the evidentiary hearing about fraudulent inducement, designation of expert witnesses, the calculation of the administrative penalty, and respondents' claim of financial inability to pay the penalty. The ALJ did not modify the proposed order as a result of the respondents' objections to it. Therefore, the ED concurs with the administrative law judge's proposal for decision and recommends adoption of the proposed order with the inclusion of the ED's exceptions, which are intended only to clarify the order and correct minor typographical errors. We are here to answer any questions you may have, and I would like to reserve the remainder of my time for rebuttal if necessary.
Thank you, Ms. Leiter. I have no questions. Commissioner Lindley, any questions? I couldn't hear you, but I did see you.
Yes, no, I don't. Thank you.
Thank you. Commissioner Janeka?
Likewise, none for me.
Thank you. So we'll hear next from the respondent. Is Mr. Aguilar or Ms. Villasenor on the line?
My name's Tony Aguilar. I'm appearing pro se, and I'm also appearing as the attorney for Benita Castillo Villasenor. Good morning.
Good morning, sir. The floor is yours.
I'm sorry, I didn't hear you, sir.
Oh, I said good morning. The floor is yours.
Okay. Needless to say, I'll make my summary short. We definitely dispute everything that the administrative judge found. Candidly, we went into this realizing that we were going to end up appealing the case to the district court. And I've given notice to both Ms. Leiter and Ms. Smith that it's going to be appealed. There's a number of problems on it, but that's not really for the commission here to deal with. It's going to be a situation of we follow the procedure and end up in the district court in Travis County. So I'm here basically for two reasons. One, out of respect to the members of the commission, and two, to answer any questions you folks might have.
Thank you, sir. I appreciate your brevity. I appreciate your presentation. I imagine there are I imagine that the district court can handle this matter after it moves out of the administrative phase. Sir, I don't think I have any questions for you just now. Commissioner Lindley, do you have any questions for Mr. Aguilar?
I don't. Thank you for calling in and participating today, though.
Commissioner Janeka?
No questions for me, but thank you very much. I sincerely appreciate your wanting to appear before us and answer any questions if we had them. Thank you.
Let's hear next from Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Amanda Pessanen for the Office of Public Interest Counsel. OPIC agrees with the Administrative Law Judge's conclusions that the ED met its burden to show that respondents committed the violations as alleged in the ED's first amended report and petition. OPIC agrees that the ED has demonstrated by a preponderance of the evidence that respondents allowed and continue to allow the unauthorized presence of toxaphene over protected limits on the site that is the subject of this proceeding, and the respondents are in continuing violation of TCEQ agreed order in docket number 2011-1833 IWHE and 30 Texas Administrative Code sections 335.2 and 335.4. Further, OPIC agrees that the penalty recommended by the ED is reasonable and calculated in accordance with applicable statutes, agency rules, the TCEQ penalty policy, and past agency practice. OPIC also agrees that respondents did not satisfy their burden to demonstrate a financial inability to pay the recommended penalty. Therefore, OPIC recommends that the Commission adopt the ALJ's proposal for decision, sustain the ED's exceptions, and issue the proposed order as modified in accordance with the ED's exceptions. Thank you, and we are available for any questions.
Thank you, Ms. Pessanen. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No, thank you.
And Ms. Leiter, did you want to offer anything in rebuttal?
No, thank you.
Thank you. Colleagues, I think we're all sympathetic to anyone who finds themselves saddled with contaminated property, but the law imposes liability on property owners whether or not that property owner caused the original contamination. And here, the respondents agreed to address contamination on their property under a previous order, but failed to do so. And that failure constitutes new and additional violations, which are the subject of this proposal for decision. And in my review of this proposal for decision, I find no basis to upset the ALJ's findings or conclusions. The respondents have admitted that they have not complied with the 2015 order. The executive director proved the violations. The executive director proved that the proposed penalty is consistent with the statutory factors and the agency's penalty policy. And the record supports the ALJ's finding that the respondents waived their claim of financial inability to pay, as we have articulated that defense under 30 Texas Administrative Code, Section 70.8. I'm also not persuaded by the respondents' exceptions, most of which were made and ruled upon at hearing. And the executive director's exceptions are, in my view, clarifying and appropriate. In addition to those, there are three other minor corrections that I would like to make, which I'll read into a motion. And let me do that, and then we can take the time we need to discuss this matter. So colleagues, I move that we adopt the Administrative Law Judge's proposed order with the modifications recommended by the Executive Director's exceptions and agreed to by the Administrative Law Judge's reply dated January 28, 2020, with the following additional changes. Finding of fact number 4 should be revised to state that the effective date of the agreed order was June 19, 2015. Ordering provision 3 should be revised to change has to have, and conclusion of law should be revised to delete the after discharge means. So that's the end of my motion. Colleagues, with that motion pending, I'd like to gather your thoughts. Commissioner Lindley, what do you make of this item?
I'm in agreement. This is a significant penalty, especially for two individuals, and so didn't make this decision lightly. But I do think the ED was thorough, and I, like you, I find no basis to overturn the ALJ's order. So I'll stop there.
Thank you, Commissioner Lindley. Commissioner Janeka?
I think I arrived at the same conclusion, and I think I understand your motion as well, Mr. Chairman, and I think that those are all improvements to the order as you suggested in the motion.
Thank you. Is there a second?
I would second.
The motion has been made.
Before we move forward, may I check for a moment and make sure that the administrative law judge's reply was dated January 28, 2020 and not 2021?
Thank you, Ms. Smith. I had that in my notes, and I read it off my notes, and now that you mention it, it strikes me as odd. Let's check that date, and then if need be, I'll make a new motion.
Well, I am looking at the date on the letter. I think we did receive it on January 28th, 2021, but it is dated 2020, which I think just may have been a clerical error from the ALJ.
All right. So
I think no need.
I think the motion as I stated it is correct. The letter was in fact dated 2020. It had the wrong date on it. We can all acknowledge that it was 2021. So I think it's probably all right that we all know which reply we're talking about, which letter we're talking about. So I think I think the motion is sufficient. The motion has been made and seconded. Let's take a vote. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 3 is the application by Chevron Phillips Chemical Company LP for a major amendment to Texas Pollutant Discharge Elimination System permit number WQ 0001006000. The parties have been notified that the Commission will not take oral argument, but may ask questions, and those who have registered will be noted for the record.
Thank you, Ms. Smith. For those who are not familiar with our process, we begin our analysis of hearing requests by considering whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And colleagues, on this application, we have a single request from Carrie Adcox. Ms. Adcox did not identify any personal concerns as I read her request. She asserted more generalized concerns that are common to the public at large. She also resides more than a mile up gradient from the nearest outfall. So in my view, she has not met the substantive requirements to be entitled to a contested case. And I think we're compelled to deny her request. Commissioner Lindley, how do you see it?
I agree.
Commissioner Janeka?
I'm also in agreement.
I will entertain a motion.
I would move that we deny the hearing request filed by Carrie Adcox, that we issue the amendments to TPDES permit number WQ 0001006000 to Chevron Phillips Chemical Company LP as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by Ameritex Pipe and Products, LLC, for air quality standard permit registration number 159336. The parties have been notified that the Commission will not take oral argument, but may ask questions. Those who have registered will be noted for the record.
Thank you, Ms. Smith. Colleagues, as an initial matter, we have several motions to continue this item to the next agenda based on last week's weather. And from where I sit, I'm not going to need to hear from any of the parties, as is usually the case on hearing requests. So at least for my own purposes, I would propose that we decline to take up those motions to continue and instead turn directly to the hearing requests. But I'd like to gather your thoughts on that. Do either of you have a reason to entertain the motions to continue, Commissioner Lindley?
I'm in agreement with you. I think it's appropriate we take it up today.
Take up, you mean go ahead and take up the substantive matter, the hearing request? Correct.
Thank you.
Okay.
Yes.
Thank you. Commissioner Janeka?
I reached the same conclusion, Chairman, and I appreciate you bringing this question up at the start of our discussion here. I'm inclined to give the full flexibility we possibly can afford to members of the public who experience difficulties in participating in our process due to the weather of last week, but this matter wouldn't normally present an opportunity for the public to participate actively, and I didn't have any questions myself after my preliminary review. When I saw that some of these requests for continuing the matter came in, I took a closer look, and I still am prepared to move forward on the item today.
Thank you, Commissioner Janeka. And just a little foreshadowing, I think this is actually a pretty straightforward matter. But again, for the benefit of those who are not familiar with our process, we begin our analysis of hearing requests by considering whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And again, requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit, and have done so in timely comments and a timely hearing request, are entitled to a hearing, except on applications for concrete batch plants. The legislature has imposed an additional requirement, and that is at Texas Health and Safety Code, Section 382.058C. The legislature has limited hearings to those persons actually residing in a permanent residence within 440 yards of the proposed facility. And colleagues, that last requirement, which is an objective statutory bright line, is, in my view, dispositive in this matter. We have numerous requesters here, but none reside within 440 yards of the proposed facility. So I come down where both the executive director and public interest counsel come down, and that is that we are compelled to deny all of these requests. And I do want to add that I appreciate that there's significant community opposition to this project. I'm sympathetic to that. I would like the requesters to know that this authorization is the result of a health-based analysis. We understand this authorization to be protective of public health and the environment, and that the application and that the authorization are consistent with the relevant legal authorities. And I hope that can provide some comfort, but in any event, it's our duty to follow the law. And here, under the provision I cited earlier, that means that there's no right to a contested case hearing. So colleagues, let me gather your thoughts. Commissioner Lindley?
Sorry. I'm in agreement. You know, it comes down pretty simply to me where I know that probably anyone that's called in and is participating today will not appreciate our decision and not like it. And, you know, for those people, unfortunately, the law is the law, and it is a clear, bright line on how we are supposed to make determinations on these kind of permits. And so with you, Chairman, I agree that I think legally, the option we have today is to move forward with granting the permit. So that's what I'm comfortable doing today.
Thank you. Commissioner Janeka.
I think you both described the situation very, very accurately there. I'm of the same, I've reached the same conclusions, and I would therefore make the motion that we deny all hearing requests and requests for reconsideration, that we issue air quality registration number 159336 to Ameritex Pipe and Products, LLC, as recommended by the executive director, and that we adopt the executive director's response to public comment.
The motion has been made.
A second.
Sorry, I need to wait for the second. It seemed as if it had been seconded, but it hadn't. But now it has. So let's take a vote. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is the application by Steel Dynamics Southwest LLC for authorization to construct a new wastewater treatment facility. On February 5th, 2021, the Office of Chief Clerk notified the parties that there would be an opportunity for oral presentations on this matter. Steel Dynamics Southwest LLC should speak first as the applicant, followed by the Executive Director, the Office of Public Interest Counsel, and anyone signed in on the matter. OGC recommends that oral presentations be limited to 5 minutes each, excluding time for answering questions raised by the commissioners. And I believe we'll begin with the applicant.
Thank you, Ms. Smith. And I understand that Mr. Hatchett was here to represent the applicant. Is that correct, Mr. Hatchett? Are you on the line?
I am. Thank you. Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is David Hatchett, and I'm here today on behalf of Steel Dynamics Southwest, LLC. I appreciate the opportunity to share a few thoughts regarding this request for authorization to construct, which, if granted, would allow Steel Dynamics to construct wastewater treatment equipment while awaiting a decision on a separate TPDES permit application that was submitted to the agency in October of 2019. While that separate permitting process proceeds, Steel Dynamics desires to have authority to construct a wastewater treatment facility. The wastewater treatment facility will be located roughly in the middle of a $1.9 billion overall facility being constructed. The 2,500-acre project near Sinton is employing thousands of South Texas construction workers on all aspects of the future facility, with the exception of this wastewater equipment at issue today. Approving this ATC will lead to a more cohesive construction of electrical, plumbing, and support functions that are present all around the future wastewater treatment facility. Allowing a particular construction crew to perform all of its skilled trade work without any artificial stops and starts leads to better quality, fewer construction-related air emissions, and more efficient scheduling of all the other contractors that depend on that work occurring in a timely manner. Importantly, granting of the ATC will not adversely impact the environment. The ATC will not authorize a discharge of wastewater and will not affect the terms and conditions of any ultimately issued TPDES permit. Steel Dynamics understands that the final wastewater treatment facility must meet the conditions found in an eventual TPDES permit and agrees to make any design or installation modifications necessary to do so. Further, Steel Dynamics understands that the ATC would not authorize operation of the wastewater equipment in a way that would require a TCEQ permit to be issued first. The particular equipment subject to this ATC can perform different useful functions and would not just sit idle in the event a TPDES permit is not issued. For example, the types of equipment to be constructed can separately stage water for use in the steel making process, can treat water for indirect sewer discharge, or can reclaim water for beneficial uses that are outside of the TPDES process. Therefore, granting this ATC will not have any adverse environmental impacts, will not compromise the TPDES process, and will not lead to any stranded assets, even if there is no TPDES permit. Steel Dynamics thanks each of you for your time and consideration. To the extent necessary, I do reserve any remaining time for any rebuttal to the extent somebody speaks out. I'm available to answer any questions you may have. Thank you.
Thank you, Mr. Hatchett. I appreciate the presentation. And it seems to me that your client had some challenge or difficulty with back scheduling the TPDES application for this facility. Are you able to describe that and give us a sense of what happened there?
So this application has now been pending since October of 2019, so we're fairly far into the timeline. It has taken some time to work through the prescribed process. There was a public meeting. I think the current status is that a response to comments document is likely being prepared. So we're moving closer, but we still have some time left in the normal prescribed process before there might be a final permit. Allowing this authorization to construct obviously will allow construction work to move forward in the interim.
Thank you. And yeah, these authorizations sometimes do take quite a bit of time, especially given all the process that is built into it, the public process. It's my view that people who are working on these projects, developing and planning for these projects, need to understand what those deadlines are and build them into their schedules. I also wanted to ask you, it seems that your client got a little bit ahead of itself and actually began construction, in this case, without an authorization to do so. Is that your understanding?
Well, we're talking about an NOV that has been issued, which I think has been submitted to the commissioners in advance of this agenda item. Obviously, that's a separate matter, but I think the short story is that the provision that at issue is Section 26.027 of the Texas Water Code. It talks about particular kinds of treatment facilities that need to wait for construction until a relevant permit's been issued. That prohibition, frankly, is not part of the Clean Water Act. It's not present in other states where Steel Dynamics has steel mills. To be frank, it was a surprise to see that application of that language to an industrial facility. We are familiar with the idea of publicly funded projects having construction prohibitions assigned to them because it's a way to avoid unnecessary governmental spending. This project is not governmental spending. This is Steel Dynamics funded, always will be. And so, frankly, they were surprised to see this application to the very limited amount of equipment that was out there. It was a couple of tanks that will in the future be available to be clarifiers, but they're not currently clarifiers. They have no plumbing, no electrical, certainly no discharge capability, no wastewater going to them. So once Steel Dynamics heard the first hint of a problem, they ceased all operations on construction, rather, of that area. And that was even before there was an inspection. And it's still in that same state today. So we are sitting and waiting out of abundance of caution to make sure that there's nothing we're doing in that area that could cross the line. So certainly the company apologizes for not understanding that interpretation of the statute. And as soon as they were made aware of it, that area ceased all construction, and we're here before you today to try to address this under the law.
I appreciate the answer. It won't surprise you that the commissioner has a different reading of that requirement. That's not really before us today, but I did want to sort of understand where your client was coming from. When TCQ's investigator visited the facility, the construction site, last November, the company's representative, the senior vice president, Glenn Pushis, told the investigator that construction of the wastewater treatment facility had not commenced and that the materials and equipment for the facility had not been purchased. Is that correct?
I personally wasn't present at that meeting, so I don't know what all was discussed. My understanding is that Mr. Pushis was explaining a couple of tanks that were out there were for water holding, and there were also some cooling tower areas that they discussed. I don't know what other detail they went into.
Okay. Some of the materials or equipment that were already there on site, including some clarifier tanks, actually were intended to be and will become part of the wastewater treatment facility. Is that correct? Is that your understanding?
Correct. Right in the middle, there are two water tanks that could and will become clarifiers if there's a TPDS permit issued in the future. Now, they have other purposes, too, in the interim if one is never issued, as I mentioned in the presentation, but that is correct.
Okay. And again, that's the subject of the separate notice of violation that you referenced a moment ago. Okay, I've got some other questions that are going to be, again, a little redundant to your statement, but I want to get it out there. your client understands that the request we're considering today is only whether to allow construction to resume and is not an authorization to operate or discharge, correct?
That is correct.
And your client understands that if we were to grant this application, that construction would proceed at the company's risk, correct?
That is correct.
And your client understands that the commission could ultimately deny the TIPD's application, correct?
That is correct.
Okay. And any action that we take today has no bearing on that decision, right?
That's my understanding.
That is my understanding as well. And your client understands that the commission may require the company to engineer a facility that's different from the one that it's planning to build now, correct?
That is correct.
And again, it's the company that assumes that risk, correct?
That is correct.
Okay. Well, thank you for all that, Mr. Hatchett. I appreciate it. I don't have any other questions at this point. Commissioner Lindley, do you have any questions for Mr. Hatchett?
I do have questions. I think I would wait and go through the other, hear from other parties that are presenting today. But I think I am going to have a question or two of the applicant, but if it's okay, I think I'd rather wait and hear what the other folks have to say first.
Sure, we can come back to that. Thank you, Commissioner Lindley. Commissioner Janeka?
Thank you, Chairman. And I appreciate you asking your questions. I shared some of those questions in my mind as well, so I appreciate it, Chairman. Thank you, Mr. Hatchett. I had one question. I wanted to confirm what I believe I heard your statement in the opening statement included, and that was effectively the statement that if you were denied the TIPD's permit, ultimately your client has other uses intended for the equipment and material that would be installed as part of the construction under this, the authorization under this authorization to construct today. And so are you telling us today that there is an ulterior use or some value, even if the permit were not issued for your client to begin and can resume their construction activities?
That is correct. That same equipment can be used for other functions, including staging water for the steel making, indirect sewer discharge pretreatment, or reclamation water for beneficial use.
I appreciate that, and that's good to hear. And I want to offer, I want to push back gently on a statement you made about the intention or some of the public policy goals of the requirement in law and in our rules prohibiting construction to begin prior to the issuance of the permit. And I would add that there's, in my view, another policy goal that's served by this requirement. And I would merely ask if you see that perhaps there is that alternative policy goal as well, and that is merely the political context of the decision before us. If I have my 4-year-old child asks me for a puppy, but he doesn't have any puppies in sight, it's a hypothetical puppy, that's a very different decision for me as a parent versus my little 4-year-old brings a puppy that he has gone out and found and rescued and taken to the vet and cleaned and taken care of. Do you appreciate that those are two different asks, where one reflects an investment that's been made and a real cost if I say no, versus one where there's less of an immediate cost if I say no?
Certainly we understand that consideration, and I don't mean to presume to state what the legislature intended or didn't intend with the language. I merely was just relaying what we had run into in other locations with somewhat similar language and how they applied it, not at all how Texas applies it.
I understand. I appreciate that, and I think that your clarification has been helpful for me. I think a lot of my initial concerns on this matter have been addressed by your presentation, some of the discussion with the chairman, but I too look forward to circling back if we have other questions. Thank you.
Thank you, Commissioner Janeka. Thank you, Mr. Hatchett. Sounds like we may get back to you with some additional questions, but let's hear next from the Executive Director. Good morning.
Good morning. Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka, General Counsel, and Public Interest Counsel. My name is Hollis Finley, and I'm an attorney with the Environmental Law Division of the Executive Director. According to its application, Steel Dynamics has requested an authorization to construct before the issuance of a TEPC's permit to allow orderly and efficient construction, along with the ongoing construction of non-wastewater treatment aspects of a planned steel mill. Steel Dynamics asserts that an authorization to construct is necessary in order to promote a more efficient construction schedule for the facility and allow for more cohesive construction of electrical, plumbing, and support functions that will be in the same general area of the proposed wastewater treatment plant. Steel Dynamics states that the construction of its overall steel plant requires extensive coordination and timely acquisition and installation of very expensive equipment over the course of an approximately 20-month timeline. Steel Dynamics states that there are currently thousands of construction workers performing $1.9 billion worth of improvements according to a carefully timed schedule. Texas Water Code 22.027C states that a person may not commence construction of a treatment facility until the commission has issued a permit to authorize the discharge of waste from the facility, except with the approval of the commission. The commission's authority to approve or deny a request for an ATC is discretionary under the statute. The approval of an ATC would not bind the commission in its final decision, and if the ATC application were granted, Steel Dynamics will be constructing the wastewater treatment facility at its own risk. After reviewing the ATC application, the executive director finds that Steel Dynamics has provided a valid basis for obtaining authorization to construct the wastewater treatment facility by explaining the necessity to allow for the orderly and efficient construction of the proposed wastewater treatment facility in conjunction with non-wastewater treatment aspects of the planned steel mill facility. The ATC application did receive one objection from the Aransas project, which asserted that Texas law prohibits construction of a wastewater treatment plant prior to issuance of a permit. However, as previously stated, Texas Water Code 26.027 prohibits construction of a treatment facility before the issuance of a discharge permit unless the commission has approved construction. Of the last 3 ATC applications brought before the commission granted 2 of those applications. In 2009, the city of Hidalgo requested and received an ATC to secure $5.8 million in grant funds from the Texas Water Development Board in meeting its deadline. In 2011, HEB sought and received an ATC to minimize the time it had to keep retail space vacant at a commercial subdivision at its existing real estate development. In its objection, the Aransas project also stated that the ATC should not be granted before it had an opportunity to prove potential environmental issues associated with a discharge permit. However, an ATC does not interfere with the public comment process or the hearing process. By law, comments and hearing requests must be addressed and considered before the issuance of a wastewater permit, regardless of whether an ATC is granted. This includes the commission's ruling on the validity of hearing requests and whether Steel Dynamics applications should be referred to the State Office of Administrative Hearings for a contested case hearing. Whenever an ATC has been granted in the past, the commission's orders have always made clear that 1, an authorization to construct does not authorize the operation of or a discharge from the wastewater treatment facility to be constructed before obtaining a permit or authorization from the commission. Also, that an authorization to construct does not relieve the applicant of any liability or responsibility with respect to obtaining a wastewater treatment permit in accordance with Texas Water Code Chapter 26. And finally, an authorization to construct does not convey any property rights or any exclusive privileges, nor does it remove the necessity of complying with any federal, state, or local laws or regulations. Since the authorization to construct would not authorize any discharge or operation of the proposed treatment facility, while also allowing the coordination of a $1.9 billion construction project involving thousands of employees, the executive director finds that granting Steel Dynamics authorization to construct is consistent with TCEQ's mission statement to protect our state's public health and natural resources consistent with sustainable economic development. I'm available for any questions you may have. Thank you.
Thank you, Mr. Henley. You came in right under the wire there. I appreciate your presentation. I had no questions. Commissioner Lindley, any questions?
I do, and I thought that was a great presentation. Thanks, Mr. Henley. And I don't know if you know the answer to these questions, and if you don't know the answer, that is okay, but I want to ask them anyway. You referenced 2 ATC requests, one from 2009, one from 2011. I'm wondering if you know much about the history of those, and what I'm curious to know is, were either of those requests brought on by an NOV? And I will just say it right now, from what I see in the record, that's what appears is what's happened to me, is that a notice of violation was found, and then Steel Dynamics came in and asked for this, and it would kind of take care of the NOV. That's what I see in the record. And I'm wondering if there's any historical context to the two that were granted, if there were NOVs involved in those cases or not. And that's kind of specific. If you don't know, it's okay. But you do know. I'd love to hear.
Oh, yeah. None of them involved an NOV in reference to an authorization to construct or constructing facilities. However, I think it was City of Hidalgo who did have some moderate violations in its compliance history. But again, like I said, it had nothing to do with the ATC.
Thank you. I appreciate that. I'm impressed you had that ready to go. And I believe that's my only question, so thanks.
Thank you, Commissioner Lindley. Commissioner Janeka, any questions for Executive Director staff?
No particular questions at this time. No, thank you.
Thank you. We'll turn now to the Office of Public Interest Counsel.
Good morning. I'm Sheldon Wayne, Assistant Public Interest Counsel. Can everyone hear me okay?
You're coming through loud and clear. Thank you.
Perfect. Thank you, Commissioner and Chairman. This application asks the Commission for the right to construct a treatment plant which seeks authorization to discharge up to 1,560,000 gallons of industrial wastewater per day. It would be discharged from 4 different outfalls, all eventually flowing to the Aransas River Tidal, segment 2003 of the San Antonio Nueces Coastal Basin, with designated uses for primary contact recreation and high aquatic use. This plant is part of a larger steel mill facility, which is currently under construction in Sinton, Texas. Based on the review of available information in this matter, OPIC is unable to support Steel Dynamics' application. The general standard provided by the Texas Water Code is that regulated entities may not commence construction of a plant before the plant's discharge permit is issued, unless authorized by the Commission. Such authorization is rarely sought and is granted sparingly. It is the exception rather than the rule. And because these authorizations are the exception to the regulatory scheme envisioned by the Texas Water Code, OPIC submits that such requests should be held to a high standard of scrutiny. OPIC recognizes that there are no specified criteria in applicable statutes or rules that guide the Commission's decision when considering this request. However, the application requests information regarding why early construction is needed, regarding the classifications and conditions of receiving water, and regarding comments and hearing requests on the underlying permit application. Though ones may have been issued in the past, OPIC is not familiar with circumstances where an authorization to construct has been granted for such a high volume industrial discharge facility. Over approximately the last 15 years, OPIC has identified only 2 instances where the Commission has granted authorizations. One, the 2009 City of Hidalgo matter, related to an expansion of a municipal facility that provided services directly to consumers and where adequate treatment capacity and wastewater disposal services for communities and significant state grant funds could have been jeopardized if construction wasn't expedited. The other, the 2011 HEB matter, related to expansion of an existing domestic wastewater treatment facility to provide for commercial real estate development. Importantly, these prior authorizations were basically unopposed. However, the underlying permit application for Steel Dynamics Sinton facility is the object of significant opposition. To date, the agency has received 58 comments, 54 hearing requests, and 86 public meeting requests. Additionally, a public meeting has been held, and the hearing request period remains open. The only previous authorization to construct matter OPIC found that related to a highly contested wastewater permit application was the 2016 Nantucket housing matter, and there the Commission denied the requested authorization to construct. It's clear here from the size and nature of the proposed plant and discharge activities, the characteristics of the receiving water, and the high level of expressed public opposition that Steel Dynamics wastewater discharge permit application is unique, significant, and controversial. OPIC cannot find that this is the type of application that should be exempted from the general statutory standard of Chapter 26 of the Texas Water Code, requiring permit issuance prior to construction. It's also concerning to OPIC that the applicant seems not to have factored the time requirements of TCEQ's permitting and public participation processes into its 20-month schedule and did not have sufficient knowledge of Texas requirements and prohibitions regarding commencement of construction. This matter is before you today only because of a November 19, 2020 TCEQ complaint investigation, which documented that Steel Dynamics had begun construction of a wastewater treatment plant before being permitted. TCEQ's January 12th notice of this violation set a date of March 15, 2021 for Steel Dynamics to come into compliance. In response, applicant now seeks this authorization by relying on a construction schedule that it developed for the Sinton steel mill, including this wastewater plant. This gives the impression that the applicant was not fully aware of TCEQ requirements at the time it developed and commenced its schedule, and now, after being cited with a notice of violation, seeks commission accommodation of the schedule that applicant created. Also, applicant cites the length of the TCEQ permitting process as a reason for granting the authorization. However, OPIC notes that the applicant could have requested a direct referral to SOA when the ED's preliminary decision was issued on October 21st, 2020. Had it done this, the permitting process would have been shortened by at least 4 months. It is for these reasons that OPIC is unable to support Steel Dynamics' application for an order authorizing commencement of construction. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have no questions for you at this time. Commissioner Lindley, any questions?
No questions. Thank you, Mr. Wayne.
Commissioner Janeka?
No, thank you, Mr. Wayne, for those remarks. I appreciate the input.
Thank you, Commissioners.
Next up, I understand that we have at least one interested person who would like to speak on this item. Mr. French, are you on the line?
Good morning.
We hear you now. Good morning, sir.
Good morning, Chairman Neerman, Commissioners Lindsay and Janeka, and TCEQ staff and attorney. So my name is Brian French, and on behalf of the Aransas Project, I want to thank the Commission for affording the Aransas Project the opportunity to voice our objections to this construction permit. The Aransas Project, or TAP, respectfully requests that you deny Steel Dynamics' request for this construction permit for their wastewater plant without prior TCEQ approval of their TPDES permit. This motion by Steel Dynamics embraces poor public policy and sets a terrible precedent for economic development in the future and for water management on the Texas coast. Currently pending before TCEQ is a request to grant the Aransas Project a contested case hearing on this very proposed discharge by Steel Dynamics. It's prejudicial to allow construction prior to a decision to issue or deny the wastewater treatment permit. The state of Texas, in its wisdom, chose to prohibit wastewater plant construction prior to permit issuance. We ask that TCEQ not deviate from the path set out by the Texas legislature. There are a lot of reasons not to allow construction in advance of permitting, in addition to bias and the fact that Texas law has a stated prohibition on construction prior to issuance of permit. Please consider the following issues prior to making a decision on this request by Steel Dynamics. First, TAP believes and would like the opportunity to prove that serious environmental issues are associated with this proposed discharge permit. The discharge into Chilpinton Creek will flow into Coconut Bay, which is used by endangered whooping cranes and Kemp's Ridley sea turtles, both of which feed on blue crabs. TAP's concern is that copper and other metals proposed to be discharged are toxic to marine organisms such as blue crabs, and especially to saltwater marine invertebrates. And not only that, but these metals bioaccumulate. TAP has requested a contested case hearing in which we will present evidence of this toxicity and other issues of concern if given the chance. And as Commissioner Janeka noted, to allow construction prior to full consideration of these environmental toxicity, marine productivity, and endangered species issues is to tip the scales against the full and careful consideration of these issues. Secondly, Steel Dynamics is asking to begin construction of the permit prior the construction of this permit after being cited for beginning construction without a permit in violation of Texas law, the Water Code. In this construction, Steel Dynamics in the investigative report, they initially denied. The time for requesting permission for construction in advance of permit issuance was much earlier in time before they were cited for violating Texas law. It seems to TAP that for TCEQ to allow Steel Dynamics permission, now that they have already been violated of the law, undermines Texas law. The Texas legislature passed this requirement for a reason, and TCEQ shouldn't reward lawless activity. Finally, TAP asks that TCEQ consider the compliance history of Steel Dynamics in considering this exemption request. Steel Dynamics doesn't have any real compliance history in Texas other than being found in violation prior to operations. However, their compliance in Indiana isn't that great. According to the Indiana Department of Environmental Management's virtual website, Steel Dynamics and its subsidiary facilities have a record of non-compliance with both federal and state environmental laws. This very site identifies 77 agreed orders and notices of violations since 1995. And the EPA's ECHO website lists 12 consecutive quarters of Clean Water Act violations at the Butler plant in Indiana. Steel Dynamics really needs to understand from the get-go that compliance with Texas law is expected and that there are consequences for violating TCEQ requirements. So to that end, we respectfully urge the commissioners to deny this request by Steel Dynamics for authorization to resume construction of this wastewater permit until such time as the commission renders a decision regarding this permit. Thanks for your service to the state of Texas and the favorable attention you afford our concerns, and I'm available for any questions, should you have any.
Mr. French, thank you for your presentation. I appreciate that. I don't have any questions for you. Commissioner Lindley, any questions for Mr. French?
No, thank you for your presentation.
Commissioner Ginecka?
Likewise, no questions, and thank you.
Thank you. Colleagues, at this point, why don't we circle back to the extent you have any follow-up questions for Mr. Hatchett or anyone else. Why don't we pose those now? Commissioner Lindley?
Sure, thanks. I have two questions, I believe, from Mr. Hatchett. First question, I'm wondering, when that equipment that was purchased that ended up being, you know, at the heart of the NOV, what was it purchased for? Was it purchased for construction of wastewater treatment plant eventually? Was it purchased for other uses? I mean, why was it purchased initially to begin with?
That probably would depend on which pieces of equipment we're talking about. But in general, the way that a steel mill works, and particularly the way Steel Dynamics operates, the vast majority of their water actually is recirculated. So it's conditioned for process use internally. And actually a very small percentage actually ends up going out to discharge. So there are pieces of equipment for sure that we would put more in the process water category that were ordered. There are some, like a clarifier, that fall more into the preparation for discharge category. And so they were purchased along with other equipment for the facility so that they would have it staged and ready and available for a construction schedule. Does that answer the question?
I think so. I mean, you know, what I'm trying to get at is the two blue cylinders that I saw referenced over and over again in NOV. You know, I can understand purchasing things in bulk, right? Because it does save cost. If someone's already going to be delivering them to you, go ahead and get them now. I can understand why a company would do that. So I'm just trying to figure out if and when they were purchased, what they were purchased for. I think you've probably given me the best answer you can, but if you want to add anything more to that, I'll gladly hear.
No, I appreciate that. So the tanks you're talking about in particular, the blue ones that are sitting there that are planned to become clarifiers, those would, if a TPDS permit is issued, be used as clarifiers to prepare the water for discharge.
And I guess what you spoke to earlier, if a discharge permit is not granted, you would still use those pieces of equipment in a different capacity?
Correct.
Okay. And then my other question, you know, I saw on the backup, I read a number of times actually, Steel Dynamics, I don't know, half-page response. It was in regards to questions 7 and 8 of the form that y'all filled out that the ED had sent you. What I'm trying to figure out is what are the potential losses if this isn't granted? I mean, I know it would save time and effort, but what are we talking here? I mean, all I saw in the backup over and over again was stated how big of a how big this project is. I mean, $1.9 billion, that is a significant project, and that's a significant project for the community. And so I'm just wondering if this is not granted, what that means for the company. What kind of losses are you talking? Because I didn't see that anywhere.
Yeah, so I don't know that I can give you a quantified number. Certainly it will disrupt the trades that are planned to be out there to do the work. It also leads to concerns about the quality of the construction. If you have to stop and start in the middle of a section, for example, a piping run, we would much prefer that the piping run be installed in one continuous mobilization by a contractor. It leads to much better quality, fewer joints, fewer welds, less chances for failure in the future for the equipment. So we think that makes a lot of sense from the construction side of the world. Of course, it would lead to delays and additional costs, but I don't know that I can quantify the actual dollar amounts to you right now.
Thank you. That's all the questions I have for now.
Commissioner Ginecka, do you have any questions for Mr. Hatchett?
I have perhaps a bit of an odd question, and I apologize if it doesn't seem clear why I'm asking or interested, but it strikes me that there's one policy implication here in this decision, and that's how it may impact or affect how your client would participate in what appears to be a likely opportunity for further discussion or contention over this permit. Do you think that there is a different legal approach that you would envision advising your client to try to engage through a set of contested case hearing requests and perhaps a docket referred over to SOA if you were denied this authorization to construct today versus if you were given that authorization to construct? Do you see that there would be any big impacts on increasing the need for your client to double down defenses of the existing plans and designs rather than being more flexible or open to changes in those designs if there were concerns that came to light through the contested case hearing process? I just ask if you might speak a little bit to that, what the path looks like in terms of our decision today. How does that alter the path for y'all going forward?
I think I understand. So I think we view this authorization to construct as completely separate from the discharge permit process that's ongoing. And I don't think it affects the underlying limits, the way that standards are applied, or any of that. I don't think there's any overlap whatsoever there. In terms of any kind of discussion with folks who are opposed, I think the company's willing to talk with folks. One of our concerns has been that some folks, I think, simply their only answer is no discharge whatsoever. There's no drop of water that in their minds can be safe, and we think that contradicts what the Clean Water Act has done in setting limits and what Texas has done in 2018 by setting water quality standards. They're set based on sound science. And so we think the answer has to reflect sound science. If it doesn't, I don't know that a discussion will go very far. If somebody is actually willing to talk about the application of the science, we're always willing to talk.
I appreciate that answer, and I think I further appreciate that it's very cloudy issues to discuss hypothetically further out, but I appreciate your answer to the extent that we can try to get into that topic here. Thank you.
Thank you, Commissioner Ginecka. Mr. Hatchett, you had reserved some time for rebuttal. I think it's appropriate, since you're the applicant, that we give you the last word. I want to give an opportunity to the Executive Director and OPIC to add any final thoughts they may have before we give you an opportunity to speak. I do understand, I just want to say for the record, that Mr. French was the only outside party interested person who registered to speak. So let me check in with Mr. Henley first. Mr. Henley, let me ask you if you have anything else that you'd like to add at this point.
The Executive Director has nothing further. Thank you.
Thank you, Mr. Henley. And Mr. Wayne, do you have anything else to add?
Thank you, Chairman. I do not have anything else to add at this time. Thank you.
Thank you. Colleagues, if you're ready, I think we're ready for Mr. Hatchett's rebuttal, and then we can take up our consideration. I see nodding, so let's go ahead and do that. And Mr. Hatchett, I believe you have about 2 minutes left, and we'll track that time here. So whatever you'd like to say in closing, we'll take those comments now.
Thank you, and I'll try to keep it much shorter than 2 minutes. To the extent it hasn't been stated clearly enough, Steel Dynamics fully understands that this APC does not affect, will not change, will not influence what the TPDS permit says or doesn't say. We're not asking for that. We don't expect that. Further, the work that will be done under this ATC has real value to the company, irrespective of any TPDS permit. So it's not like it's going to be wasted effort. And then third, granting the ATC does not itself impact the environment. It doesn't authorize a discharge. It doesn't allow us to do anything different in terms of emissions to the environment. And so we see it as a relatively small event environmentally. Certainly procedurally, we understand what we're asking for and appreciate the Commissioner's consideration of this request. But in terms of the environment, we don't think that this harms the environment in any way.
Thank you, Mr. Hatchett. Colleagues, I think we're ready to take up our deliberations here, and I'll put you on the spot. I'm still gathering my thoughts on this, so let me turn to you and see what you think. Sure, Lindley?
Oh, man. I was really banking on you going first. So what will probably happen is I will share my thoughts. You two gentlemen will say very insightful things. I've actually been very curious to hear what you guys are going to say on this item all week. And then I might very well have other thoughts because I do think this is worth a discussion. So right now, and these are where my thoughts are, and it will be, I think, pretty evident how torn I've been on this all week. You know, since I started diving into it, I have flip-flopped. I will tell you all that. Okay, I have so many notes in front of me. I'm going to try and not be too repetitive and try and keep my thoughts in order here. So, you know, I agree with Mr. Hatchett when he said, I don't think the ATC is an environmental issue. I don't. I think what it appears to me is that Steel Dynamics got an NOV, and this is potentially an effort to correct that. So I agree that if we grant this or don't, then it's not an environmental thing. This is a policy thing for me. There's been stuff today that has been said that has really given me pause, and it's kind of changed my mind as we've been sitting here going. If people don't understand Texas rules, that bothers me. And I have, like I said, it gives me real pause to want to give a company something when they say that when they read the rules, they didn't think it applied to them. And I know I'm paraphrasing. Those are not the exact words used, but that's kind of what I heard. So I'm wondering how I can ever answer the question, if asked, how I gave authorization to a company that acknowledged that they didn't understand Texas's rules. And I'm really stuck on that thought. But I will also say the reason why I'm so torn is because the law does allow this. The law does allow for a company to come in and seek this authorization and for us to grant it. And people don't do it often, but it is allowed. And it does not, at the very forefront of my mind, I'm very, very much aware of how big of an impact this entity will have on the local community, San Patricio County. I expect, assuming if they were to eventually be operational, that the financial benefits this company would bring to that community would be really significant. And, you know, we're charged with protecting human health and the environment and considering economic development, again, paraphrasing. But all that said, I want to hear what you guys have to say, but I'm just not sure I heard or was provided enough in the record, and that's really what this comes down to. I thought the ED did a good job in their documentation, and I kind of hate to disagree with the ED, but I did not see enough from the applicant in the record to quite get me there. But I'd love to get y'all's thoughts, y'all's interpretations. I will stop there.
Thank you, Commissioner Lindley. Commissioner Gnecca, what do you think?
I appreciate that as well, and those are really good thoughts, Commissioner Lindley. I'm in agreement across the board largely, and I think that I'm almost grateful as much as I'm, find it less helpful to hear from, Mr. Wayne, for example. His always appreciate hearing from OPIC. I think he named exactly many of my concerns and articulated exactly where I see some of the weaker points in this decision before us are. And I think that the question of whether the authorization to construct is an environmental issue or an environmental question, I agree entirely in terms of, at the moment, it is not. It does, however, I have to observe, have the potential to rise to the level of an environmental issue if it is seen by the public as prejudicing our later decisions, our technical decisions. And so on this point, I'm really sensitive to it, and I think that this really comes down to a question of public trust. It's the agency, the commission is being asked by the applicant here to take them at their word, to enter into a relationship of trust that yes, they understand they're entering into a period of risk, because there's the very real possibility that after the engagement with the public that every applicant and every member of the public is due in this state for an environmental authorization, they may come out with some set of some findings that would point back at the beginning and say you need to change your course, or it's not appropriate for here, and that creates a very difficult policy-making environment for state leadership, for our agency, and I think the legislature recognized that and put this trip, this stopgap here, and it's appropriate for our agency to rule on this decision. And I guess I can only say, in terms of making an actual decision today, I'm really inclined to give very high deference to the executive director's analysis on this. I think their familiarity far outside of our scope and what we're able to consider and look at today in terms of our sight over the record, I think the executive director staff has the level of sophistication in making their recommendations to us for the authorization to construct, to really analyze the underlying application upon which this would rest. And I don't think that I'm troubled by the prospect that ED is veering off on a course and considering this application where there's any real high risk of adverse or surprising findings coming back from SOA, or maybe even this may be a situation where there doesn't appear to be a high likelihood of parties being found to be affected parties. And I don't want to suggest that those decisions ever are predisposed or decided at any point in time, but we're sophisticated actors, and I think that we're really good at communicating back to entities when they're chasing after something that's not attainable, and we can recognize that and have that conversation. So I'm inclined to give a lot of deference to the executive director, and my expectation that conversation is occurring behind the curtain where I can't necessarily see it. I think that this is a very infrequent decision that we receive that comes before us. I'm not sure, Chairman, that you would have been ruling on the 2016 decision that came before the commission previously, or last came before us, the Nantucket housing matter. So I'm not sure whether you've seen this before or not, but certainly this would be the first one of these that I've seen. And so I would merely suggest that maybe you would have an adverse reaction, since it's a so rarely a once and always. Maybe instead of being predisposed to granting, this may have the opposite effect, where I hope that we don't find that this makes it harder for us to give what would later be a grant an approval on this decision. I think I'm starting to chase myself around in circles on this point, but I'll make one last observation, and that's merely that I think that this decision would have been very easy and a very different one, and I have to acknowledge many of the difficult points that Commissioner Lindley pointed to in terms of the timing of the notice of violation, what appears to be just a misunderstanding of Texas law. It definitely raises some immediate questions of concern right on the front end, and this would have been a very easy, not easy, but a very different appearing question, I think, if this request came in a year ago, well in advance of any construction occurring anywhere on the site. But we're where we are today, regardless of anything else. And I think that on balance, I'm inclined to give a high degree of deference to the executive director. I think I would be prepared to move forward today in granting the authorization to construct, acknowledging that I think it's going to make it really hard for me, and I'm really going to hold the applicant at their word here today that they can use this facility whether or not they get the underlying permit. And I think that I'm going to be giving, and I acknowledge that might not be a factor that I'm even going to be able to consider in that decision as it comes around before us. But I think just as a past policymaker, it would really make it a harder decision in my mind if they were to come to a different conclusion. What other surprises about Texas law may come to the applicant's attention between here and where they may ultimately get final action on their underlying permit application? So all that said, I'll pause there, stop, and see, Chairman, if you have anything to add, and perhaps let Commissioner Lindley circle back around and jump in as well.
Thank you, Commissioner Janeka. And let me just review some of my notes in the disorganized fashion that they're in, just to share some thoughts. Commissioner Lindley, like you, I'm troubled that the applicant didn't seem to understand the state authorities that they're operating under, that they're maybe their consultants missed this, failed to build enough time into the schedule for consideration of their TIFDs application, failed to shorten that timeline by not availing themselves of direct referral. I do think that the size and nature of this facility is relevant. The fact that there is significant opposition to the permit itself, separate matter, but that is out there, which creates a greater possibility that there could be changes required in the plan. So the lack of planning is a little troubling, and the view of Texas authorities is a little troubling. I have to be candid. I am bothered by this. I have developed the impression that the company's representative may not have been entirely forthright with our investigator. That seems to be a real possibility in this case, and that's in the back of my mind, and I find that troubling. It really is the subject of the NOV and that investigation and enforcement process, but it does weigh on me in this consideration. The applicant is before us asking for this, this exception to allow them to proceed without being able to speak to what it will cost them specifically. Your question, Commissioner Lindley, I think is a great one. What is the burden? What are we talking about here? The policy and precedent implications do give me pause. I think that, I'm confident in my own abilities, and I'm confident in you, colleagues, your ability to avoid any bias that might come to bear if we were to grant this application in how we proceed on the TIFDs application. I'm confident that we can sort that out dispassionately and not be biased by any action we take on this application. But there is a public perception issue that is unavoidable, and Commissioner Janeka, you spoke about public confidence and public trust. So, those are thoughts that are weighing on me. On the other side of the ledger, this is a project that is going to confer economic benefit. I mean, sure, it accrues efficiencies to the company, but it also accrues economic benefit to the county and the state. The point that Mr. Hatchett made about the quality of the construction, that makes sense to me. That is a reasonable point. I agree that there are no environmental impacts, no negative environmental impacts if we were to grant this application. I think Mr. Hatchett may have suggested there may even be some marginal efficiencies around environmental impacts such as air emissions, perhaps negligible. But the point is, what we're considering today does not have environmental consequence, and I think we've been very clear that this would be a proceed at your own risk authorization, and Mr. Hatchett has been kind enough to be very redundant on that point at my urging. Yeah, that's how I see the issues stacking up, and it's a tough one. On balance, I think I think we disfavor these kinds of applications. So where does that leave us?
The elephant in the room. I'll chime in first, I guess. This is just so tough. We have had a lot of tough decisions, and this one for me is very difficult. Even while you gentlemen are talking, I'm questioning what I'm thinking in my mind. I think where I'm going to land is I just go back. I tried to take out all the other noise, right? And for me, all the other noise was what's happening with the actual discharge permit application. Not to discount what's happening there. That's a very significant permit, and it is being contested. But I tried to pull that away and just focus on what is in the record, what was in the record in front of us today. And just to be very candid, it looks like to me the ED did a good job in laying out his remarks today, or Mr. Henley did a good job laying out his remarks today. I thought their findings of facts were well written and very good, but I wanted more from the applicant in the record. I don't feel like the applicant gave me enough in the record to give 2 thumbs up, hands down. And that pains me because I'm very supportive of I shouldn't say that. I would want to be supportive of a project that's going to benefit a community that this one might potentially one day do. Of course, there's a lot of things that have to happen before any of that could happen. And I say could. I'm rambling. Let me just cut to it. I didn't find enough in the record to grant this authorization, and that is very painful for me to say. But I didn't feel like I got it from the applicant, so I'm going to stop there.
Thank you, Commissioner Lindley. Commissioner Ginecka, you want to say anything at this point, or?
I will just share the sentiment. I think Commissioner Lindley named exactly another point that I was a bit troubled by, and that was that the basis of the record for which we're being asked to make this decision is a little light in terms of I think particularly just because of the size of the facility, the timing. With where they are in construction, where they are in seeking their other underlying permit. But I think that the part of that question may rise to perhaps we may ask the ED staff at a later point in time, or if y'all agree today, this application for this sort of an authorization, this request, it's something that so rarely is seen. It strikes me that part of the brevity of the order before us reflects the fact that it's a roughly 3-page application, a form that we ask applicants to fill out, and there's relatively short fields for a few of the answers, a couple of which the applicant availed themselves of the appendices to stick on more information, but still was on balance with the size, scope, complexity of this project, maybe felt a little sparse. So I will share the sentiment that Commissioner Lindley raised and suggest that if there's room to fix it, perhaps we might ask ED staff to take a closer look at this underlying authorization to see if there isn't perhaps some guidance which we could try to flesh out what we want to see to consider these requests, and then where concerns would be. That's all I'd add on the good additions and input she just provided. Thank you.
Thank you, Commissioner Ginecka. Let me make a suggestion that may not be helpful, but it's worth mentioning. And this is really a separate matter as to the TIPD's permit, and that is Mr. Hatchett and Mr. French I would encourage you, if you haven't already, explore whether there is any agreement on what a reasonable permit might look like, and if there's, just engage each other and see if there's any room for that discussion. It's a long shot. Maybe I'm being overly optimistic, but it might be fruitful. So let me put that out there. Second, for the reasons that have been discussed, this is a very difficult decision. But ultimately, to cut to the chase, I come down with Commissioner Lindley. So I'm going to make a motion, and then we can allow some further discussion and see where that takes us. So, colleagues, I move that we deny the application of Steel Dynamics Southwest LLC for an authorization to construct. And I'll take either a second or any discussion, and we'll certainly leave some more time for discussion if we want it.
I will second, but again, I agree with opening up for discussion, more discussion needed.
It's and not to put you on the spot, Commissioner Ginecca, but it is a very challenging issue for all of the reasons that we've discussed.
Well said. And now you're putting me on the spot of do I help support the sense of commission comedy or not? But I appreciate that. I'm prepared to take the vote today.
And Commissioner Jack, let me just say, I think we usually vote unanimously. When we don't do that, it has never had a hint of affecting the comedy of the commission. I certainly have a great deal of respect for each of you and your views and what you bring to this, and I don't view my view of the world as being any better or more important than yours or Commissioner Lindley's. So don't
I also second that comment.
Don't let that factor into your thinking.
Well, I will show me voting nay on this issue, please. Otherwise.
All right. Well, let's go ahead and call the vote. The motion has been made and seconded, and that was the motion to deny this application. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecca, how do you vote?
Nay.
I also vote aye. The motion carries. Ms. Smith, please call the next item. Actually, Ms. Smith, let me interrupt you for a second. I ran out of water and I am parched. I'm going to, colleagues, propose that we take a 5-minute recess. Let's call it 6 minutes, and we'll reconvene at 11:10. Is that all right with you? All right. With that, we stand in recess. right, the time is 11:10, and we're back in session after a short recess. Commissioner Lindley, I see you there. I think Commissioner Janeka is here as well.
Sure.
With that takes us to our enforcement docket. Ms. Smith, I'll ask you to please call that caption.
Items 6 through 18 are our enforcement docket. The Executive Director's staff is here to present these matters.
Thank you, and good morning. And staff, before you get started here, I understand that there is some interest, some public interest, and we're likely to hear public comment on item 6 today. So if in your presentation you want to say anything about that item, or at least be on notice that we may have some additional questions about it, I thought I would flag that for you. And with that, the floor is yours.
Thank you for that. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 18. The total assessed administrative penalties are $247,526, with $32,370 deferred, $18,750 applied toward supplemental environmental projects, and $196,406 to the general revenue. At this time, we respectfully request approval of these items, but we are available to answer any questions on any of the items on the docket. Thank you.
Thank you, Ms. Cordell. And I don't have any questions at this point. Colleagues, any questions? Commissioner Lindley?
No questions. Thank you.
Thank you. And Commissioner Janeka, how about you?
None, thanks.
Okay. And Ms. Smith, I think this is the time we ask any interested persons for their comments. Who do we have signed in to speak?
That is correct. On item 6, we have multiple individuals, and we also have some people who are signed in on item 6 who said that they didn't wish to address the Commission, and their presence will be noted for the record. To allow enough time for everyone who wishes to be heard during the meeting, the Commission will limit initial comments from each speaker to 3 minutes and extend that time if needed. On item number 6, I understand that there is also a pending permit application for this entity, and I just wanted to remind everybody before they speak that this is an opportunity to address the Commission only on the enforcement matter that's pending, and that comments should be limited to the enforcement matter. There will be additional opportunities provided by the agency to comment on the permit specifically, but today we're only noticed to talk about the enforcement matter. So with that, the first person on my list is Stephen Graff.
Thank you, Ms. Smith. And I'll ask you to, if you would, just direct traffic and call the commenters on this and keep track of the time, since you have that at your fingertips. And with that, Mr. Graff, please identify yourself for the record and go ahead, sir.
Yes, hi, good morning, Commissioners and Mr. Chairman. My name is Steve Graff. I reside at 2 Haywood Court on the north side of the Hunters Creek subdivision. That's roughly 3/4 of a mile northwest of the facility. I live with my 2 boys who are now in 5th and 7th grade, respectively. On May 9th, 2018, both of my boys were students at Isabel Elementary, which is close to the plant in question, and they were forced to evacuate the school on that day of May 9th. Along with the disruption to education and the distraction of that event, the plant was a frequent source of eye irritation to my wife, who sought treatment. After the elementary school evacuation, my family and neighbors were not contacted by TCEQ investigators. For this reason, we are concerned that the full impact that the plant has had upon our community, even in so-called normal operating conditions, remains unknown by the Commission. I believe that the enforcement action penalty on this industrial plant should be reconsidered until after the Commission staff has been able to better establish its effect on the community and our children. And I and my neighbors remain resolute in this belief. Thank you for your time and consideration.
Thank you, Mr. Graff. We appreciate your comments. Thank you very much for participating in the meeting today. It's important for the commission to hear firsthand from the citizens and how they're affected. For your benefit and anybody else who's paying attention, and there's no reason that you would know this, but I wanted to let everyone know that there's also an opportunity to provide written comments on the record. And again, I wouldn't expect anybody to know this, but when these orders are drafted and proposed, they're published in the Texas Register, and that gives interested persons an opportunity to put their concerns and comments in writing. It gives us a little bit of a head start in thinking about and considering those comments. So I wanted to let you and others know that people can avail themselves of that opportunity as well. But we are delighted to take your comments in the public meeting as well. That's what it's here for. So thank you again, Mr. Graff. And Ms. Smith, you can go ahead with calling the other commenters.
The next person on my list is Nick, and apologies if I'm not correctly pronouncing your last name, but Nick Hagenhoff.
Hagenhoff, but that'll work. All right. Good morning, and thank you, TCEQ commissioners, for your time. Hopefully everybody can hear me.
Loud and clear. Thank you, sir.
All right. So my name is Nick Hagenhoff. My address is 15054 Snowshill Drive in Frisco, Texas. My family and I live approximately 250 yards from the APAC facility since 2011. I understand the purpose of the meeting here today is not in regard to a judgment for the facility in terms of operation and permitting as part of the larger process with the enforcement action. My story is similar to many. Going back to 2011, we purchased our home, noticed the noxious fumes from the plant becoming a part of our daily lives, impacting outdoor activities with my family and overall quality of life. I'm sure you can imagine having to come inside from playing outdoors because your wife and kids are wheezing from the fumes, and then dealing with those same noxious odors indoors as well. So we suffered through that for 7 years. As Steve mentioned, Isabel Elementary had emergency response on site due to the fumes from the facility on May 9th, 2018. Giving you some insight on that event, our son was among the other students that were evacuated from the school. He suffered intensified wheezing and coughing symptoms for the next several weeks. In my opinion, this is unacceptable and seemingly typical of other students in attendance that day. And I would respectfully ask any of the commissioners of children to try to put themselves in the same shoes as our community during that time frame. So bigger question would be, what track record has this facility shown in previous attempts to have them regulate their operations? In addition to the recent monetary fine assessed enforcement, I believe there are some technical requirements that have been laid out as well. Interestingly, a previous basic requirement was that APAC spray their stockpiles to reduce particulate matter and dust emission by 70% per TCEQ. Based on a subsequent TCEQ investigation, 1498299 on page 6, there's a representative Ulstein from the plant stated that stockpiles are, quote, never watered because it would make the production process difficult. This is but a small example of failed attempt by APAC to hold up the requirements set forth by the commission and lacks good faith to properly operate at their current location. My closing point is that they were willing to forego the most basic tasks required by TCEQ previously. It broadcasts their intentions and lack of due diligence being a reliable and ethical member of the local business community. I would like to believe TCEQ has done their absolute due diligence in light of this most recent violation and make sure we're not evacuating Isabel Elementary or any other schools again if the facility comes back online in the future, and that the enforcement action is approved. Thank you for your time.
Thank you, sir. Ms. Smith?
The next person on my list, who I'm also liable to incorrectly pronounce the name, so apologies, is Randy Halipsock.
That's okay. Can you hear me?
Yes.
Yes. Okay. I'd actually like to defer to Alicia. I was hoping to speak last. She is on this call as well, so she should be able to just pipe in and get going.
Yes. Hi. Thanks, Randy. This is Alicia Patrick. We have selected 5 of our residents to speak on behalf of the whole neighborhood. Believe me that there are definitely more stories and concerns very similar to ours for everyone who is on the line listening, even though they're not speaking to you. We appreciate your time. We're going to try to be concise and precise to respect that. My name is Alicia Patrick, and I live at 15163 Daneway Drive in Frisco, Texas, which is just about 2,000 feet from the asphalt plant. Like others have said, on May 9th of 2018, Isbell Elementary was evacuated due to the fumes from the asphalt plant seeping into the school building. And that was only one of hundreds of times those fumes have seeped into not only that school, but these schools nearby, as well as our homes, since we've lived here since 2009. My youngest was still a student at Isbell during the evacuation. She told me that she was covering her face because the fumes were so strong they were making her eyes, nose, and throat burn. She still felt like she couldn't breathe because even through her shirt, it was still burning. In addition to all of that, she also got a terrible headache, which was very common every time. As a family, collectively, we suffered headaches, burnings in our eyes, nose, throat on the days that the asphalt plant was operating. Since the plant has been shut down, though, we have no longer had these issues, and it's been wonderful. The plant is no longer a nuisance. We are able to go outside and enjoy our amazing neighborhood and surroundings. I know the plant was investigated for many violations in 2018, but TCEQ never contacted me personally to hear my family's story, and I do not know of any other neighbors who were contacted either. I do not believe the investigation conducted was thorough enough to get the whole picture of the poor air quality our neighborhood has been dealing with for over 10 years prior to TCEQ's investigation in this matter. I am concerned that the penalties and fines assessed do not accurately reflect the repeated violations of this asphalt plant. To be specific, TCEQ investigators found that on 13 different days, the plant exceeded the burning temperature by an average of 14 degrees, and that the records of those temperatures were missing dates, had hours of operations that did not match information in other records, and had other discrepancies which made it difficult to determine the compliance. It is consistent that APAC Asphalt Plant admitted to completely falsifying information and data on these records so that they would meet the acceptable requirements set forth by TCEQ. The data was a lie. None of it was true. Since TCEQ was determined that the records kept pertaining to the max temperature made it difficult to determine compliance, and in light of the fact that the company is known to have violated the max temperature rule on at least 13 separate occasions, isn't it possible that the company had additional temperature violations in the days that the records do not determine compliance? Along with that, on the days that the company exceeded the 14-degree average, it begs to question, wouldn't that be more harmful amounts of pollutants than just on a mild? Therefore, it is appropriate to use the 14-degree average to reach 13 days when determining whether than actually causing minor harm. Shouldn't the staff instead score each of the 13 days on the max temperature exceeded for that day to determine if, on that day, the harm to the neighborhood was minor, moderate, or severe? Is $5,000 really an accurate fine when an average was used for every day, thus getting a minor violation instead of using the actual degree for each day? This plant has consistently ignored and violated the rules set forth by TCEQ for over 10 years. May 2018 was only the first time these issues was not the first time these issues occurred. More investigation is needed to clearly assess. Thank you for your time and consideration.
Thank you, Ms. Patrick. Ms. Smith, who's next?
Mr. Ian Schneider.
Can you hear me?
Yes.
Yes.
Go ahead, sir.
Ready? Okay, thank you. All right, Commissioner and Chairman, my name is Ian Schneider. I live at 6793 Branch Trail. That is within 3/4 of a mile of the plant, as well as my children used to go to Isbell Elementary, which is, as you know, just a few hundred yards away from the plant. I'm here as a clinician and a parent. I'm here to clearly state that the penalties in the investigation by TCEQ was probably not thorough enough, although I do appreciate TCEQ's involvement in controlling the violations by this plant. Until you have witnessed someone take their last breath from a pulmonary disease, you cannot tell me that these penalties are adequate enough to justify letting this plant continue to function. This plant, I think, is well documented, has repeatedly and blatantly violated regulations set forth by the TCEQ. As you had mentioned before previously, to quote you guys, the company has not been forthright with the investigators on the previous case that I listened to. So I think that applies perfectly to this situation as well. In regards to the evacuation in May 2018, I think that has been discussed ad nauseum. There's over 700 students and 150 staff members that are evacuated. My children personally did suffer nosebleeds, headaches, cough, burning eyes, watery nose. The list goes on and on. They also suffered emotional damage, saying, "Daddy, are they going to poison us again next time they go to school?" That's something a parent should never have to hear them dropping their kids off at school. Since the plant has stopped functioning, my son has been weaned off of three different respiratory treatments, daily respiratory treatments. His PFTs, his pulmonary function tests, have improved significantly, and my daughter no longer has daily headaches. Let me give you a quick example. If you came into my office complaining of shortness of breath, coughing, inability to perform your activities of daily life, inability to play with your kids or grandchildren because of the air quality, and I did some simple basic tests on you and easily diagnosed you with a problem and said to you, "I have the cure, but I'm not going to give you that prescription for the cure. I am not going to give you that medication for that cure," you'd be pretty frustrated too. So I think that example applies to this as well. I will say that the air quality in this neighborhood is severely compromised. Our activities are severely compromised. Our quality of life is severely compromised. And I would appreciate TCEQ investigating further. I have documented meticulously medical records. I would like them to audit the nurses' records in the school to see how many kids have gone there for pulmonary treatments, albuterol, inhalers, things like that. I would like that to apply to our attorney, because I think that's important in reviewing these records and these violations. Just to remind you guys, according to the mission statement on your website, your goal is to provide clean air along with water and safe management and base decisions on law, common sense, sound science, and responsibility. So I think that applies here as well, that this enforcement needs to be followed through in a stricter manner and allow this plant to feel what we're feeling as citizens living next to it.
Thank you, Mr. Schneider. Ms. Smith, who's next?
I think that was the end of my list. If we wanted to go back to Randy Halepsuk. Thank you. Sorry.
That's okay, dear. It happens all the time. So the image you see, that's my daughter and my husband, Evelyn and Andy, in our home on Blake Hill Drive, which is 1,000 feet from the permitted site. I'll reiterate my name. It is Randy with an R, Halepsuk, Haluptzok, and I am speaking on behalf of myself, my husband, and our 5-year-old daughter, Evelyn. I would be curious to learn what an appropriate price is to put on the health and well-being of a community with over 1,200 members and approximately 4,000 individuals who are directly impacted by this plant's gross negligence and willful misconduct. Is $21,000, which amounts to about $5 a person, sufficient? And if so, will the community impacted by the plant's carelessness actually see this $21,000 to help offset medical costs and negative health effects incurred over the years? Will I see my $5? And what about the future? Will the plant pay for the negative health effects that will be forced on this community once they resume operations? We have over a dozen affidavits and letters from community members, and we can get more, that go into great detail of the health impacts incurred by this plant stemming from this particular event in 2018, as well as other events at the site. I would like to drill down to the reality of the proposed remedy on this enforcement action. The technical requirements issued for this action really just puts the onus back on the community to continually lodge complaints and reach out to TCEQ each time the plant violates their permit requirements. It baffles me that their permit is being considered for renewal with such an egregious history of abuses and failure to adhere to their permitting requirements. Therefore, I respectfully request that TCEQ include the performance of frequent, random, and unannounced site visits on a weekly basis with this enforcement action, because up until the elementary school was evacuated in 2018, TCEQ rarely, if ever, sent reps out to monitor compliance unless a complaint was made. And by that time, it was already too late. It was the next day, and the plant had modified their behavior. In an effort to keep my comments within the allotted time, I would also like to request that TCEQ please refer to the materials that I furnished with our contested case hearing submitted in June of 2019. There is a very detailed spreadsheet in that documentation with a number of issues that outline the specific 2018 event, specifically beginning on row 67 of that document. In conclusion, I'm respectfully requesting that TCEQ please send this back for further review. Our community is extremely worried that this penalty determination was made without a full consideration of the impact of not only this event, but any prior event and the subsequent impact and improvement of the health of our community since this event has caused the plant to cease operations. Please have your staff send reps out to interview the neighborhood. Please seek out medical records from the community and school staff at Isbell. Please perform additional investigations to ensure if this remedy is truly sufficient, which we wholeheartedly believe you will determine is not adequate. If you will please interview those members of the community like Ian, who just spoke, who have been directly and quantifiably impacted by the gross negligence and willful misconduct of this plant over the years. I believe these requests are very fair. Thank you for your time. I really appreciate it.
Thank you very much, Ms. Philipstock and Mr. Schneider, Ms. Patrick, Mr. Hagenhoff, Mr. Graff, and to your neighbors for organizing your comments and presenting them today. I'm not going to have any questions for you. I think you've made your point with great clarity, and but let me check in with my colleagues. Commissioner Lindley, any questions for the commenters?
No, I would just comment that I'm very impressed with how organized and I thought the comments were very well put together.
Thank you, Commissioner Ginecka.
I'm very appreciative to hear these concerns and troubled to hear firsthand accounts of the circumstances the community are troubled by with this actor. I've seen many parallels to other sites where we've heard similar concerns raised. So I'm certainly eager to be responsive. I think in terms of the specific medical concerns, the requests to have our investigators make contact with every member of the community to make sure they have a full, complete picture. I'm in strong agreement with the spirit of those, but I think the practicality of them really defeats our agency from ever being able to accomplish that end goal. So I will say thank you for that suggestion and really put it to the community. Y'all are very well organized and helping us considerably in terms of the number of complaints that helped initiate this particular violation that's before us today. And I will say that is the necessary tool in our agency's toolbox, in that the weekly visits from our inspectors may or may not be practicable as other urgent facility incidents or response activities or other complaints and allegations come in. Our inspectors are constantly having to juggle very limited resources. And I will just commend the community in continuing to bring these issues to our attention, because that's the best and quickest way that we can try to address them.
Thank you, Commissioner Ginecka. And before we move on, I want to I understand there may be a representative for the company on the line, and I want to give them an opportunity to address the commission. Is there a company representative present?
Good morning, Mr. Chairman and Commissioners. This is Sam Ballard representing Texas Materials Group, Inc., or TMG for short. Can you hear me okay?
Loud and clear. Go ahead, Mr. Ballard.
Okay, great, and appreciate the opportunity to respond. So I would first like to say that both TMG and TCEQ have invested considerable time and resources to reach a settlement on this enforcement action. And in fact, the parties have worked together on this matter for over a year to ensure that the settlement was carefully well thought out and in the interest of all parties involved, including the nearby homeowners. And importantly, this is a 1660 order, and contrary to one of the comments made this morning, TMG has not admitted to any wrongdoing or violation. And TMG is certainly aware that some homeowners in the area hold TMG responsible for a temporary school evacuation in May 2018. While the school evacuation was certainly an unfortunate event, TMG completely denies any responsibility for that. TMG was unfairly pegged as the scapegoat for that event, when in reality, the Frisco Fire Department determined that fresh tar on a road near the school had actually caused the alleged odor. Once the Frisco Fire Department made that determination and cleared the scene, the students were let back in the building, and this is all documented in a Frisco Fire Department report that TMG has shared with TCEQ, and this was all taken into account when the parties reached this proposed agreed order. TMG takes environmental compliance very seriously, and has taken steps to ensure that its plant does not emit any offensive odors. As an example, TMG plans to implement a different type of odor treatment technology than it has previously used when the plant reopens. This technology generally involves treating the odor at the exhaust of the baghouse rather than treating it in the liquid asphalt tank. And this has been clear with the TCEQ, and TMG firmly believes that this particular odor treatment technology will be of great benefit. And I should also note that TMG is not a repeat violator, as indicated in the proposed agreed order, and has maintained a high compliance score at the site, contrary to the comments made previously. Therefore, the current penalty amount is more than sufficient, and TMG strenuously objects to any proposed increase in the penalty amount. An increased penalty amount is simply not warranted in this case. And finally, Commissioners, while TMG does appreciate the comments made today, I would like to note for the record that none of these individuals filed written comments on the proposed agreed order when they had the opportunity to do so. The comment period closed several weeks ago, and TMG is not aware of any written comments filed on the proposed agreed order. So with that, TMG would respectfully request approval of the proposed agreed order, and I thank you again for the opportunity to respond, and I'm happy to answer any questions you may have.
Thank you very much, Mr. Ballard. I have no questions at this point. Commissioner Lindley, any questions for Mr. Ballard?
No, thank you.
Commissioner Janeka.
I apologize if you mentioned this and I missed it in your testimony, Mr. Ballard. Is the plant currently does it remain out of operation currently? And what could you speak a little to the plans for when the company expects to resume operations, or what the current posture is?
I can speak on when the plant shut down. It shut down August 10th, 2018. It has not been in operation since then. And I am personally not aware of when TMG exactly plans to reopen. So unfortunately, I can't speak on that particular question, Commissioner.
Appreciate that. Thank you. No other questions.
Thank you. Why don't we go ahead and hear from Public Interest Counsel about the docket generally and especially any specific comments if you have any on this item 6.
Good morning, Vic McWhorter, Public Interest Counsel. My office reviewed all of the enforcement order items on your agenda today, and we recommend approval of the orders. Specifically with respect to item 6, obviously we're sensitive to the concerns of the community. We are familiar with these concerns, and we've heard them in the past, and we know that this community has been affected by the incidents they've described, and we're very sensitive to that. With respect to the order that addressed this particular situation, we think the staff has acted appropriately in reviewing the information required under our penalty policy, and that the order reflects that. That being said, and this is not unique to this particular situation, when it comes to air nuisance violations, these are very problematic situations with respect to documentation and proving violations. And I think everyone at the agency at one time or another has had some frustration with how difficult that it is to capture the impact of these types of events. But with all that said, we do recommend approval of the proposed orders. I'll also say, without going into the details of another matter that is related but not before you today, any future actions regarding continued operation of this plant or permitting, I promise you that our office, I can only speak for my office, will definitely be taking all of the background into account when we move forward with any future proceedings regarding the permitting of future operations of this facility. Thank you.
Thank you, Mr. McWhorter. Colleagues, any questions for Public Interest Counsel? Commissioner Lindley.
No questions. Thank you.
Commissioner Janeka.
Thank you. None.
All right. Well, this item 6, without the benefit of written comments, I didn't see this coming until it was too late for me to dive into it to the depth that I feel like I now need to dive into it with, but something doesn't add up. There seems to be a disconnect between the proposed penalty amount and the testimony that we've heard today. So that suggests a number of different procedural paths that we might take, and I'd like a few minutes to have a sidebar with Office of General Counsel to think through and explore those before I propose a particular path. Any thoughts or ideas you want to share before we take a short recess?
I don't have any. I'm fine with a short recess.
Commissioner Janka? Okay. All right. Well, why don't we aim at being back on the record at 11:45, and with that, the time is 11:41, and we stand in recess. All right, colleagues, the time is 11:45 a.m. and we're back on the record after a short recess. I think I've sorted out my thoughts on a possible path forward on this. But before I get to that, I wanted to give Ms. Cordell or someone from the executive director's staff an opportunity to provide any additional thoughts or comments they would like to on this item 6. If any, you don't need to, but I just wanted to afford that opportunity. Ms. Cordell, are you there?
Hi.
Chairman, this is Brian Sinclair for the Executive Director.
Okay, good morning, Mr. Sinclair.
Good morning. We are, the comments, certainly the comments from the folks who spoke this morning were very compelling, but, as OPIC mentioned, it is very challenging in these kinds of cases where you have nuisance odors to kind of make we are limited to addressing the nuisances that were documented in the investigation, and as expressed earlier I believe by Commissioner Janeka, that basically the challenge is that the penalty often doesn't seem to match the level of concern and impact as expressed by members of the community in some of these cases, and it's very challenging for the for executive director and both from an investigator point of view and from the enforcement division point of view to really capture all of that when you're limited to what's documented in an investigation. I know we have Jess Robinson also available to speak, and I could let Jess make whatever comments he would like to make in addition to mine.
Thank you, Mr. Sinclair, and Mr. Robinson, to the extent you have anything to add that might help us out, please go ahead.
Good morning, Chairman, Commissioners, Office of General Counsel, and Office of Public Interest Counsel. My name is Jess Robinson. I'm Litigation Division Staff Attorney assigned to this matter, representing the Executive Director. I don't want to repeat any of the points that have already been made, which are very understandable, and I appreciate them very much. But I would like to respond specifically to an additional comment that concerned the facility's compliance history. I would just like to point out that the compliance history period, as set by Section 60.1B of the TCEQ's rules, for this matter, was a 5-year period that ended on the date that the initial settlement offer was mailed, which here was February 4th, 2019. Should there be any future enforcement efforts, which the TCEQ, of course, has a continued statutory responsibility for, the compliance history classification and components will be assessed pursuant to the requirements of Chapter 60 at that time. For this matter, the classification, including any identification of repeat violator, was set pursuant to the timelines for this case.
Okay, and I'm sorry if I didn't quite get the point, Mr. Robinson. Are you saying that, for example, if we were to remand and recalculate the penalty on this item, that the compliance history classification would be different, and therefore the penalty would be affected by that, and further that negative compliance history information might roll off, and so that would end up accruing to the benefit of the respondent if we were to recalculate? Did I understand? Am I getting that right?
My apologies, Chairman. I had not intended to say that. Instead, what I had hoped to communicate was only that what exists on the compliance history report as is relevant and feeds into how the penalty is calculated for this matter. It was set when the initial proposed settlement agreement was mailed by the Enforcement Division. At this time, I would not expect for the compliance history period and therefore any components to change if this enforcement matter were to be remanded and continue to be developed. I don't expect that the compliance history period would change. I was speaking to if something were to happen in the future for an entirely new enforcement case.
Okay.
But I don't want to make any presumptions. I was hoping to just make the point that Chapter 60 outlines what will exist on the compliance history and its components for enforcement cases.
Sure. Thank you, Mr. Robinson. And believe me, no apology necessary. This is complicated stuff, and I have a hard time understanding a lot of it, even though we work in it every day. But absolutely no apology necessary. That's clear to me. Anything else you'd like to add, or is that the extent of your comment, Mr. Robinson?
I suppose that I would only reiterate that the current information that is known to executive director staff is consistent with the representation made that the facility is out of operation currently, that the violations that are laid out as alleged in the proposed agreed order were based off of information that was documented in our investigation report. And to my knowledge, in my review, the penalty was calculated consistently with what was called for by the penalty policy and based off of the evidence that was contained in the investigation report.
Got it. Thank you, Mr. Robinson. Colleagues, any questions for Executive Director staff? Commissioner Lindley?
No questions. Thank you for that.
Commissioner Janeka?
None, thanks.
Thank you. I'm going to make a motion and then explain and allow for discussion after the fact. Colleagues, I move that we adopt items 7 through 18 and further that we continue item 6 until the next agenda meeting. So that's my motion. I'll invite a second in a moment if there is one, but let me explain that. Face value, this isn't adding up. The testimony that we heard today and a proposed penalty of $21,000 just raises questions in my mind. It sounds like there are reasons for that. There may be good reasons for that. Both the Executive Director's Office and our Office of Public Interest Counsel that takes an independent look at this have concluded that that this order is appropriate. And they do a very good job. I appreciate their analysis. I just want to make sure that I understand the analysis and am fine with that. Sort of trust but verify, and I'm going to need some time to verify, which is why I'm suggesting that we continue the item. The downside is that the parties don't get their answer today. So that's why I proposed continuing this item. Separate and apart from this enforcement action, I am very concerned about, this operation interfacing with this neighborhood seems to, not be a good situation. And separate and apart from this proposed agreed order, I want to urge our staff to help find solutions so that's not the case. And I intend to have a sidebar with staff to discuss strategies around that. But that's the rationale for our motion to not act on item 6 today, but to take it up again next week. Thoughts, Commissioner Lindley?
I'm comfortable supporting that motion. I just to be very transparent with the public, especially, the 5 representatives of the community. And I know that was just a representation of all the people that are either listening or will be in tune with what's happening. It might not change. The penalty might not, but we do owe it, at least to myself and sounds like the chairman, and I'll let Mr. Janeka speak to a minute, to go back and relook at it. But I just want to state that it could change and it could not. But I am comfortable with your proposed motion of just adopting items 7 through 18 today and continuing item 6.
Thank you. Commissioner Janeka?
I wouldn't have any objections to proceeding as you lined out. Sounds good.
All right. Did I hear a second?
I'll second. I don't know if we did, but I'll second.
What you said before sounded like a second, but now,
It did.
now we have one with some certainty. So the motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 19 is the consideration of the monthly enforcement report. The Executive Director's staff is here to present these matters.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Brian Sinclair of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through December. There were 355 effective administrative orders issued, and of those, 47 contained supplemental environmental projects. These orders assessed a total of $3,432,301 in penalties, with a payable amount of $2,291,496. $563,746 are to be paid for supplemental environmental projects. 4,784 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 493 enforcement action referrals have been received. There are 1,507 pending administrative orders with 213 cases that are on the backlog. 208 cases are pending at the Attorney General's Office for representation in District Court, and 5 judgments have been issued. 2,044 cases are being tracked for compliance. We have concluded for review a summary of OCE investigative activities for fiscal years 2019, 2020, and 2021. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I don't have any questions. Commissioner Lindley, any questions?
I don't have any questions either.
Commissioner Janeka?
And I appreciate the report.
Thank you. Ms. Smith, I assume there's no one signed in to speak on this item.
That's correct.
Thank you. And Mr. McWhorter, what are your thoughts?
I don't have any questions, and I also appreciate the report.
Thank you. Colleagues, no action is necessary on this one, so we can move on to the next item. And to Executive Director staff, thank you very much for the report. We appreciate that. Ms. Smith, please call the next item.
Item number 20 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapters 35, regarding emergency and temporary orders and permits, temporary suspensions, or amendment of permit conditions, and Chapter 291, Utility Regulations, to implement portions of Senate Bill 700 and House Bill 3542. The Executive Director's staff is here to present the item.
Thank you, Ms. Smith. And I had to check the clock to make sure I can still say this, and I can barely, but good morning to Executive Director staff. You might check to see if you're on mute.
Good morning. I think that Brian may be having trouble with his audio, so I will go ahead and make the presentation.
Thank you.
Can y'all hear me now?
Oh, we hear Brian now.
Okay. Sorry about that.
That's all right.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Brian Dickey with the Water Supply Division. With me is Benjamin Worms with the Litigation Division. The adopted rulemaking would implement House Bill 3542 from the 86th Texas Legislature 2019 regular session to amend requirements related to appointment of a temporary manager to a water or sewer utility with fewer than 10,000 taps that has violated a final order of the Commissioner for the conditions listed in Texas Water Code Section 13.4132A3, and implement Senate Bill 700 from the 86th Texas Legislature 2019 regular session to allow the Commissioner or Executive Director to issue orders to ensure safe drinking water or environmental protection and emergency interconnects. The legislation also allows the Commission to delegate to the Executive Director to receive applications and issue emergency orders under Texas Water Code Section 13.041H. The proposed rules were published in the October 16, 2020 issue of the Texas Register. A virtual public hearing was held on November 10, 2020. The public comment period closed on November 17, 2020. The Commission received comments from the City of Belton. Although the City of Belton expressed concerns that the rulemaking lacks necessary details and considerations, it did not
provide any suggested revisions to the proposed rule language. No changes were made to the proposed rule language. Staff respectively recommends adoption of this rule making to Chapter 35, Emergency and Temporary Orders and Permits, Temporary Suspension or Amendments of Permit Conditions, and Chapter 291, Utility Regulations. Staff also respectively requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Dickey. I have none, but just a quick observation as to the City of Belton's comments. You know, what they read as lack of specificity, I see as flexibility that's necessary for us to deal with the, whole panoply of situations that might come at us. I appreciate staff's work on this. Commissioner Lindley, any questions for staff?
No questions, thank you.
Commissioner Janeka?
You captured it very well, Chairman Yearman. That I think the points that the city expressed some concerns about are a feature, not a bug. It's intended flexibility. I'm comfortable with that.
Thank you. Ms. Smith, has anyone signed in to speak on this item?
No one's registered on this one.
Thank you. And let's hear from the Office of Public Interest Counsel.
OPIC recommends approval for adoption of revisions to the Commission's Chapter 35 and Chapter 291 rules to implement House Bill 3542 and Senate Bill 700 as presented by the Executive Director.
Thank you, Mr. McWhorter. I agree. This is a legislative implementation rulemaking that was carefully crafted in coordination with the Public Utility Commission. Again, I appreciate the work that went into it. I'm ready to move forward with adoption. Colleagues, where do you stand?
I'm in agreement. I'm ready to move forward as well.
I'll entertain a motion.
Likewise here, I will make the motion that we approve the adoption of amendments to 30 Texas Administrative Code Chapters 35 and 291 as recommended by the Executive Director.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
Items 21 through 24 are for closed session, and the Commission will not be meeting in closed session today.
Thank you, Ms. Smith. And now, in fact, it is afternoon. The time is 12:02 p.m., and we are adjourned.